The question is, when does a single rogue employee's personal misconduct become a multi-million-dollar corporate liability? Under the common law, the baseline is a doctrine known as vicarious liability, holding an employer legally responsible for the actions of their employees. If a delivery driver causes an accident while on the clock, the company pays the damages for that negligence. Vicarious liability is a proven tool for common law torts like negligence, but applying it to statutory breaches, violations of specific written laws passed by Parliament, was legally unmapped territory prior to 2006. The case that forced the courts to map this boundary was Majrowski v. Guy's and St. Thomas's NHS Trust, heard before the House of Lords. The outcome shattered the assumption that corporations are automatically shielded from the statutory crimes of their managers. The conflict began with William Majrowski, a clinical auditor working for a major medical institution within the National Health Service, or NHS. Majrowski was subjected to severe workplace bullying by his departmental manager. The harassment included frequent homophobic remarks, excessive criticism of his performance, and deliberate professional isolation. Majrowski executed a sharp legal pivot. Instead of suing his employer for common law negligence, he weaponized Section 3 of the Protection from Harassment Act 1997, or PHA, a statute designed to create civil remedies for victims of harassment. The NHS Trust took an immediate defensive posture. They argued they had committed no wrong themselves, and therefore could not be held strictly liable for a rogue manager violating a distinct statutory law. The stakes were massive. If Majrowski succeeds, the line between a poorly performing manager and a corporate statutory violation dissolves. To understand the trust's defense, we must look at the legislative intent behind the PHA 1997. Parliament primarily drafted it to combat criminal stalking, not to regulate human resources disputes. Looking directly at the text of the PHA 1997, something is conspicuously missing. The phrase vicarious liability does not appear. Because the statute is silent, the trust argued Parliament intended only to punish the individual stalker, balancing the scales purely toward personal liability. This defense was highly intuitive. Corporate compliance professionals widely believed that statutory silence equaled corporate immunity. But relying entirely on the literal text of a single act ignores the overarching invisible architecture of the common law. This fundamental question of statutory interpretation was ultimately tested at the appellate climax, the House of Lords. Lord Nichols laid out the foundational reasoning. He started with the premise that vicarious liability is a common law principle of general application. Because vicarious liability is a general principle, it automatically attaches to statutory duties by default, not by exception. Unless a statute explicitly states that liability is restricted only to the primary wrongdoer, the court will presume vicarious inclusion. This specific jurisprudential mechanism destroyed the NHS Trust's defense regarding the PHA 1997. Majrowski flipped the burden of proof. Employers are no longer protected by statutory silence. They are threatened by it. Establishing that vicarious liability can apply to a statute is only the first step. To trigger strict corporate liability, the court still needed to determine if it applied to this specific manager's actions. Enter the close connection test. This Venn diagram maps the test. It differentiates arbitrary personal attacks from actions linked to employment duties. The intersection triggers liability. The Majrowski facts sit exactly in this intersection. Her legitimate duties were the tools used for harassment. The Lords found the harassment wasn't incidental. She weaponized her actual managerial authority, specifically setting targets and reviewing performance, to commit the statutory breach. When an employer grants managerial authority, they underwrite the risk of that authority being used to commit a statutory tort. Handing down their final judgment, the law lords ruled the NHS Trust was vicariously liable for the manager's breach of the Protection from Harassment Act. Majrowski confirms the mechanics of vicarious liability do not discriminate between common law and statutory duties. For HR directors, risk management cannot rely on the isolated text of an act of Parliament. The common law serves as a wrapper around statutory rules, making the employer the ultimate underwriter of their manager's conduct, regardless of the statute's original intent.